your argument next in case 2350, Chiaverini versus the City of Napoleon. Is that on? Mr. Chief Justice, and may it please the Court. Everyone in this case now agrees that as the lack of probable cause element of a malicious prosecution claim under the Fourth Amendment, the charge-specific rule governs. That is, the plaintiff may make out a malicious prosecution claim by proving that one charge is not supported by probable cause, even if other charges are, provided, of course, that the plaintiff also makes out the other elements of the claim. As no one appears to dispute, that charge-specific rule is supported, as Chief Judge Fryer put the point, by both centuries of common law and by bedrock Fourth Amendment principles. That's all this Court needs to address to resolve this case. Respondents urge this Court to go beyond that ruling to weigh in on a series of open questions about a different element of the Fourth Amendment malicious prosecution claim that resulted in a seizure element. No one disputes Mr. Chiaverini is going to have to prove that on remand. But weighing in on the kind of precise contours of that question would require this Court to go beyond the question presented to address issues not aired at all below, that haven't percolated in the courts of appeal, and to do so on the sort of briefing that doesn't have the kinds of text, history, common law arguments that you'd expect before weighing in on an element of a constitutional tort. As in Thompson, this case involves a narrow dispute over one element of a Fourth Amendment malicious prosecution claim. This Court should simply hold that a plaintiff can make out a claim by showing that at least one charge lacks probable cause, again assuming they can make out the other elements of the claim, and remand for consideration of everything else. I welcome this Court's questions. What do you have to show, if anything, about causation? If you have a situation where you've got three allegations and two are concededly valid and they justify the seizure, you still get relief? Don't you have to show some kind of causation? Yes, Your Honor, we agree there has to be some kind of causation. We think the formulation in Thompson is correct. You have to show that the malicious prosecution resulted in a seizure. Our position is that if you want to weigh in on precisely what the counterfactual is, the 11th Circuit's position is correct. That the correct counterfactual is, could this have been done as a warrantless arrest? The 11th Circuit... could the plaintiff have been seized for this length of time or seized for this length of time based on a warrantless arrest? So the way the 11th Circuit articulates it is, look, this legal process was corrupted. We know this legal process was necessary if the detention is longer than 48 hours, right? That's a Fourth Amendment requirement. You've got to have legal process for a detention that's longer than 48 hours. And so because this legal process was necessary, what you have to show is you prevail unless this could have been done as a warrantless arrest.
Well, I thought the evidence was that the first two of the crimes would certainly support what was done in this case without regard to the third.
So that's correct, Your Honor. Would support in the sense that a magistrate could constitutionally have signed this arrest warrant, but in fact, no magistrate did sign this arrest warrant based on just those two charges. So based on this kind of court's case law, so for instance, we cite the Eastern District of Michigan case in our opening brief, where the court says, that's the case, remember, where the Attorney General says, I can sign warrants to authorize wiretaps. This court says, surely a magistrate would have signed off on these warrants, right? Surely a magistrate would have caved to the national security concerns and signed these things. Still a Fourth Amendment violation because the magistrate didn't do so. Again, I think this is all beyond the scope of the question presented, and frankly, because there are indications from precedent and common law to support the 11th Circuit's rule, at the very least, this court shouldn't go any further than it did in Thompson in just defining kind of precise contours of the resulted in the seizure element.
Giving up on the SG's position that as an alternative to the 11th Circuit's view, that if you can show that you were retained for longer, or that, as you argued below, I understand, at least in one of your arguments, that you would have never been arrested, you would have been given a summons to appear as the person who sold you the jewelry was, so you would have never been in jail, that would be enough. Are you giving up on that as?
No, Your Honor. So we don't have much of a dog in this fight. We think that we win under the 11th Circuit's rule. We win under the SG's rule. As between the two, we think the 11th Circuit's rule is more consistent with this court's precedent and with the common law. But again, we think that you should make that decision on the basis of some briefing about the text of the Fourth Amendment, founding era practice, common law, none of which you have before you.
We shouldn't reach it, is what you're saying.
Yes, that's right.
Well, what if I think it is subsumed within the question presented? What is wrong with the logic of the Solicitor General's position? Under Thompson, an element of the claim at issue is a seizure, and that's necessary to bring us within the Fourth Amendment. So your client was seized when he was arrested, and under Thompson, he experienced a continuing seizure during the period when he was in jail. And so the question is whether either his arrest or the length of his detention was the result of the so-called money laundering charge. I don't know why this statute is called money laundering, because it doesn't seem to have anything to do with money laundering. But what's wrong with that logic? It seems to follow step by step.
So again, Your Honor, I think we win under that test, right? So the police officer's affidavit in this case says we are seeking a warrant because there is a felony of the third degree. So I don't want to push too hard on this. I think that's a totally acceptable result from our point of view. The reason that we think that it's not the best way to interpret that resulted in a seizure language is twofold. The first is what Williams explains is that the entire point of requiring a neutral and detached magistrate to weigh in is to give that neutral party the opportunity to weigh the law enforcement interests against the privacy interests. And so doing this sort of counterfactual, predicting what the magistrate would have done, kind of undermines that goal. And so I think the Williams rule, which basically says, look, if you could have done this as a warrantless arrest, right, if you didn't need the warrant, you didn't need to have a Gerstein hearing, you only detained him for a few hours, then it's fine if the warrant process was totally corrupt. That was just something bonus you were doing. But where the warrant was necessary to the detention, you could not have detained him for 4 days without a warrant, then we're not gonna kind of peer in and try to figure out would the magistrate have reached this exact same result if it knew the actual charges against?
What if the other charges on which there was probable cause were also felonies, and maybe even more serious felonies than the so-called money laundering charge. Would you make the same argument?
So I don't think we'd be able to make the same argument about why we win under the United States' rule. But I think that the 11th Circuit.
I think you should win anyway.
I think under the 11th Circuit's rule that's the defensible, and you can imagine, right? I mean, let's say some of them are.
Why? What if one of the charges is murder, and there's probable cause to support the murder charge, and then they throw in this money laundering charge? Or let's say it's an assault. Let's say there's a video when the legitimate owners of the ring came to the store and they were causing a fuss. Your client pulled out a gun and he said, get out of my store, I'm gonna blow your head off. So he's charged with an assault as well as money laundering. Same result?
So, just as a preface, I think that this is the reason you should let these rules percolate, right? We should figure out how these rules actually play out in practice. The reason I think it's the same result, what the Williams court would say is, there's a reason police officers lied about this charge, right? And so we're gonna assume that they lied about it in part because they needed it to be able to detain the person.
Well, this is, the facts of this case are disturbing and you may well win, but we're talking about what the general rule should be. So your rule would apply in a case where the police officers act in good faith, but they just don't have probable cause. It's not limited to a case in which there was perjury or the false or the manufacture of false evidence, right? Your rule is not limited in that way.
So that's correct, but we think that another element, right, the mens rea element, which this court hasn't weighed in on yet, and on which there's a circuit split, is the proper element to do the filtering that Your Honor is talking about. And the reason why I think the more serious, less serious charge rule, so to be clear, I think that's a rule we could certainly live with. We win under that rule. There's some evidence in the common law, the Newell Treatise, for instance, seems to suggest that the charge lacking probable cause should be the more serious charge. So we think there's some warrant for it, but the reason we don't think it's the best option is because you can imagine a situation, for instance, where the felony charge is a white-collar offense on which, no one's ever going to be detained. The misdemeanor's a resisting arrest charge, and the magistrate says, that indicates some kind of dangerousness. That's the reason I'm going to detain him. And so I don't think you can have a kind of categorical, more serious, less serious charge rule. And again, I think what the 11th Circuit's rule does is it says, look, at the point where this legal process has been tainted, remember, this court's cases like Gerstein and County of Riverside say if there was no legal process, right, if there's no arrest or Gerstein hearing, we actually don't care if there's all the probable cause in the world.
Well, you're talking about being tainted. Now then you're back to the idea that Officer Everhart lied, right? But what if he had? What if there's just there's no indication that there's a lie, there just wasn't probable cause?
Sure, Your Honor. So I think in that circumstance, first, probable cause, remember, is a low bar, right? It's just a reasonable belief. And second, qualified immunity will almost certainly protect the officer in a situation where there's no probable cause, but even the judge is confused and thinks there's probable cause.
Yeah, well, it will protect the officer, but it won't protect the municipality.
That's true, Your Honor. But I'm having trouble thinking of a situation where a judge signs this thing, right? Signs the arrest warrant, signs off on the Gerstein hearing, knowing all the facts the police officer accurately reported, and yet there's not even probable cause.
Can I ask you a question about the 11th Circuit rule? I just want to make sure I'm understanding it. I had thought that one distinction, and maybe it doesn't matter until you can tell me if it does, is that in Williams, it was actually the crime for which he was being detained and for which probable cause had been manufactured was the tainted crime, and the other crime for which there would have been probable cause if a warrant had been pursued was the one that had not had the adequate process. And that's a different situation than we have here, right? Because here, there was a valid warrant for the misdemeanors, right? It was just the money laundering. And so you actually had that process observed for the two misdemeanors. In a way that Williams, it was kind of like, it was blank, right, on the other side. And so there was no valid process holding him. Why does that not matter? I gather you think it doesn't.
So I don't think it does because Williams is very clear. This is at 1165. That Williams will prevail if he establishes a genuine dispute about whether at least one of the two charges against him for attempted murder, right, so remember there's attempted murder as to two different officers, the holding is he only has to prove that one of those lacked probable cause. This is at 1165. So it's true that in Williams there was also this uncharged offense, but Williams just says you have to prove one of the two charges in the actual arrest warrant was bogus.
Okay, and then I want to understand the distinction, or that I think is a distinction between your position and, say, the SG's. Do you agree that a seizure, that you have to show a seizure for purposes of making out your claim?
So, we agree that you could just continue to reiterate the Thompson language, which has resulted in a seizure. We don't think this court should use this case to go further and say that there cannot be a malicious prosecution claim predicated on, for instance, the unreasonable search clause or the warrant clause. We don't think that this is the case that tees that up.
Well, the search clause, sure, but I mean, is it going farther? We've said that before. I mean, you have to make out a Fourth Amendment claim, and here your claim is for seizure of the person. You didn't make, I don't think, a separate claim about the seizure of his effects being unreasonable.
So below we did argue at the seizure of his effects as well as about the unreasonable search. What's come before this court is this one. Yeah, and so all we're saying is that you shouldn't, and I think we agree with the SG on this, you shouldn't reach out and affirmatively say there can be no other Fourth Amendment malicious prosecution.
I'm sorry. Is one of your elements that you have to prove is lack of probable cause with respect to the one crime, and that caused an unreasonable seizure?
The language in Thompson is, and the malicious prosecution resulted in a seizure, which we think is consistent with any of the rules before.
Fighting with saying that it caused an unreasonable seizure.
Yes, the malicious prosecution caused an unreasonable seizure.
Are you accepting that language, or are you fighting that language?
So, I don't mean to quibble. Thompson has resulted. It is important. So I think the Thompson formulation is correct. Resulted in a seizure. The other elements get you to the unreasonable part.
What are the other elements? If it doesn't cause an unreasonable seizure,
So it must cause the...
why don't you just list what you think the elements are?
Right, so the appropriate mens rea, which this court hasn't resolved, favorable termination, initiation of legal process, lacking probable cause, so that's where the unreasonable part comes in, resulted in a seizure. All we're saying is don't double count the unreasonable. You don't have to prove something separate from the mens rea plus lack of probable cause.
So,
Miss Anand, I have a question about the element that brings us here today. Sure. Which is the initiation of legal process lacking probable cause, right? Am I? That's right. Okay, and that's separate from the causation. Exactly. That we've been discussing. I guess you're now saying that everybody's on the same page that the Sixth Circuit was wrong about that. Is that right? Okay. And I'm trying to understand why the Sixth Circuit was wrong, and I think I have a theory, and I'm hoping you can help me to determine whether or not I'm right about this. I'm wondering whether the Sixth Circuit, whether they were just taking what is a basic principle related to probable cause in another context. The other kind of Fourth Amendment claim that one might bring is the unlawful seizure, false arrest, etc. There you have no probable cause, and we would say that if there are 3 or 4 different charges being brought and your claim was unlawful arrest, when you proved lack of probable cause with respect to only one of those 3 or 4 charges, we would say, too bad, you still lose. Right? So it's sort of like the same idea that the Sixth Circuit was latching on to, because there are cases that say that, but it seems like they're in a different context. They're not malicious prosecution theory. It's the unlawful arrest theory. So it's like probable cause is doing different work depending upon the theory. Does that make any sense? That's exactly right. So that's exactly how the Sixth Circuit justified this rule. Yeah, it said the same rules apply to false arrest and malicious prosecution, but both at common law and in this court's Fourth Amendment cases, there has always been a distinction between the warrantless arrest context, where, as Your Honor notes, doesn't matter if the officer had 1 charge or 10 charges or 0 charges in mind. What matters is if there's probable cause out there somewhere. And the legal process cases like Gerstein and Franks and County of Riverside, where you're required to specify the charges. And that's for a couple of good reasons that I'm happy to explain. Is one of them because the malicious prosecution context is really about the culpability of the process server. It's about the person who's initiating process maliciously. It's not really about whether you were committing bad behavior, whether you were... So in other words, you could have a person who actually is a criminal,
right? He's committing crimes, but here for charges 2, 3, and 4, but if charge 1, there was no basis for it, baseless, and maliciously added on to the thing, that person would still add on to the indictment, that person would still have, at least theoretically, a claim for malicious prosecution with respect to that charge. That's exactly right, and that's reflected again in this court's Fourth Amendment cases. So to take an extreme example, Gerstein says that if you don't have process, right, no warrant, no hearing, doesn't matter if you're actually guilty of absolutely everything, it's still a Fourth Amendment violation because we care about the process. The Fourth Amendment says what makes a seizure of any duration reasonable is that someone neutral and detached weighed in and signed off on this. It's not just the police officer's discretion. And what the any crime rule would do would basically move this back into police officers' discretion if they could just lie to the magistrate about the set of charges they have on them. So what are we disputing here? Both sides agree that the Sixth Circuit got it wrong. I guess I'm trying to understand why we're continuing on. I don't know what is left of this case if the fundamental issue has been essentially resolved. There's no one else. Should we have appointed someone on the other side of the question that was presented here? So I don't think so because, I do think respondents are arguing for an affirmance on a sort of waiver plus this other element theory. I think that this just means it's an easy opinion to write. So just last week in Sheets, this court said when there's radical agreement that the court below erred in applying a categorical premise, we leave all the kind of additional nuanced arguments for remand. I think this court should follow the same course here. Radical agreement is a good thing if it exists, but I'm not quite sure there is radical agreement here. I thought the argument on the other side, which is presented in respondent's brief and also in one of the amicus briefs, which I don't have with me, is that the Sixth Circuit had a prior decision in which they essentially adopted the Solicitor General's position, and what they did here should be understood in light of that. Isn't that the argument on the other side?
So I think the other side is making two arguments. One is the one that Your Honor articulated, which is that somehow the lower court secretly was applying a different rule, but as the United States says at page 23, that description conflicts with the language of the decision below.
Yeah, okay, so there's a dispute about what they did here. Whether they were following, I've forgotten the name of the earlier Sixth Circuit.
How's it? Yeah.
Okay, whether they were following that or not. So, there's not really radical agreement. As much as one might like to have it.
So, I think that there is disagreement about how the caused a seizure resulted in a seizure element works in the nuances, right? What counterfactual you run, how exactly, whether it's the legal process could or the bogus charge would have or the bogus charge could have. But that's a separate element from lack of probable cause. And I think everyone agrees that the decision below, which said because probable cause existed on at least one charge, his malicious prosecution claim fail, full stop, right? That's the holding of the decision below. Everyone agrees that's not correct. That's not the rule.
And just to clarify on the caused the seizure point, your position, say we don't reach it on remand, would be doesn't matter if it actually caused the seizure, doesn't matter if these misdemeanor offenses would have led to the same amount of the 3 days in detention. That would be your position, right?
So I'd articulate it slightly differently. I would say that the tainted legal process surely caused the seizure. So in other words, he could not have been held for 4 days but for this arrest warrant or some other form of process.
And why? Would what was it, 3 days or 4 days?
4 days.
4 days, okay, so would 4 days be an unreasonable length of time for a detention for the 2 misdemeanors?
It's not that it would be an unreasonable length of time, it's that Gerstein and County Riverside say that length of detention must be authorized by a neutral and detached magistrate, and here a neutral and detached magistrate didn't say you can detain him or even arrest him for this length of time, except for, without knowing that the felony charge was bogus.
So you mean, just to make sure that I understand, it's possible that he could have been held for the 4 days if the magistrate had only had in front of him the 2 misdemeanors, but you're saying that the presence of the third necessarily corrupts everything else, and so the causation element doesn't run there.
That's exactly right. And again, the only published circuit court case analyzing this question came to that result. So, I think again, this court should weigh in on that question with the benefit of kind of full briefing, argument, some sort of historical analysis, and we just don't think that's presented here.
Thank you, Counsel. Justice Alito? Well, just out of curiosity, the 4 days are Friday to Monday, right? It's over the weekend.
That's correct.
And what happens in the city of Napoleon? I looked up how many people are. It's not a big city, right? Or what happens with people who are arrested on a Friday?
So, remember, County of Riverside says that a Florida statute that says you can exclude weekends from the 2-day calculation of
What happens in that town?
So,
That's irrelevant. I am somewhat curious about the facts of this case. This is a crazy little incident. Why didn't your client just give the police officers the ring?
well, Your Honor, he asked for the opportunity to consult with counsel because the hold letter was ambiguous, right? It said both hold this as evidence and return it.
I know, there's basic behavior on both sides, but look, when the police officers are there saying, give the ring to the people who... Why doesn't he just give it to them? He paid $45 for this.
So, Your
What did
Honor,
you think was gonna happen? Something's bad is gonna happen to me because I've got this ambiguous letter that says hold the ring or give the ring to the... I forget their names. Give the ring to them. Something terrible's gonna happen to me if I give them this ring when the police are telling me to give them the ring.
So, Your Honor, maybe that goes to the reason why the Sixth Circuit found probable cause for the retaining stolen property charge, but it is nothing about felony money laundering.
No, I understand. And this is not really a money laundering statute, right?
That's correct, Your Honor. It's about purchasing with knowledge. And again, even if Your Honor's correct, and I just want to say that the facts aren't quite as Your Honor suggesting they are, it certainly doesn't justify the police officers going out, doctoring a report, securing an arrest warrant, finding a way to detain him for 4 days, seizing his property.
I'm not getting it. I'm just wondering about the facts of this. What did you say it wasn't as I suggested? What did I suggest that wasn't factual?
So it wasn't that he refused to give back the jewelry, it's that he asked for time to consult with counsel before he did so.
Okay. Justice Sotomayor? Having worked many a Saturday night to arraign people before judges, that's what some jurisdictions do. Justice Gorsuch? Maybe an idiosyncratic question. But on this causation element, one way I think of it is this, that malicious prosecution at common law was all about protecting the judicial process. And so the 11th Circuit, or your view of the 11th Circuit's causation holding makes a great deal of sense in light of that common law background. That it doesn't matter what actually happened, what mattered was the process was tainted. The problem I have is that we've thrown malicious prosecution into the Fourth Amendment context. And the seizure's gotta come around someplace in the Fourth Amendment, because that's what it says, right? And that's where I struggle on how to put those two things together, because to me, a malicious prosecution claim naturally flows from the due process clause, and it wouldn't require you to show anything other than the process was tainted. So help me out with that. But that's not what we've done. Okay,
That's the first one.
I understand that.
Setting aside this court's cases, I do think that Gerstein and County Riverside says a matter of the Fourth Amendment process matters, right? So Gerstein says, yes, you can make a warrantless arrest, but you've got to bring the person in front of a magistrate as soon as possible, certainly no longer than 48 hours. And Gerstein doesn't say, and it's okay if you actually did the crime, no need to bring them before the magistrate. It wants the process, even if the...
I'm with you on due process.
But Gerstein
process.
So, but I'll just say Gerstein situates that right in the Fourth Amendment.
Okay. Let me ask you another idiosyncratic question. So, you brought a straight-up malicious prosecution claim under the common law in count one. Your client did. Also brought this Fourth Amendment hybrid thing in count three, I think it was, and got removed at federal court. I don't understand why. Malicious prosecution in state law is a pretty easy tort to prove. Not always, but you might have had a really good shot and got punitive damages and your attorney's fees and everything. Why are we making a federal case out of this?
Well, Your Honor, again, setting aside this court's recent cases saying we're entitled to do that.
I'm not questioning. I'm not questioning.
Sure.
I'm just asking purely strategically. I've struggled to understand why some of these cases wind up in federal court when, as an old plaintiff's lawyer, I might have wanted to bring it in front of the
state court. So there's a couple of reasons. Just speaking at a high level generality, so many states don't allow malicious prosecution against law enforcement. So like California doesn't allow that. In many states, there's a heightened mens rea. So in the Sixth Circuit, the mens rea for the federal malicious prosecution tort is lower than for the state malicious prosecution tort.
Tell me a little bit about that. What is that split?
I can tell you the precise split, which is that the Fourth, Sixth, and DC circuits say that the mens rea element is purely objective. Other circuits have imposed some sort of malice or heightened requirement.
Objective mens rea. Okay, got it. Alright, and did you have anything else you wanted to add? I'm sorry I interrupted you.
All I wanted to say on that front is just that it was alright to bring the Fourth Amendment malicious prosecution case, and that's not just from Thompson and Manuel, where I understand that Your Honor disagrees, but dating back to Gerstein and County of Riverside from the 80s and 90s, saying, and Justice Scalia explains it, that the idea of a reasonable seizure at the time of the founding, what the framers anticipated was you arrest someone, you bring them before the magistrate right away. That's what constitutes a reasonable seizure. So this is a matter of what is a reasonable seizure, not just as a function of the due process clause.
Thank you. Justice Kavanaugh? Justice Barrett? Justice Jackson? Thank you, counsel. Mr. Shine, Mr. Chief Justice, and may it please the court, I'd like to address Justice Alito's and Justice Jackson's questions about what exactly everyone is fighting about here today. I think the main disagreement is about how far the court ought to go in its opinion and what issues it should decide. I understood petitioner to be saying that the court should say simply that it is possible to bring a Fourth Amendment malicious prosecution claim even when a valid charge